Do you want to text Mr. Durham and tell him I'm back? There he is. Perfect timing. Unmute.
Sorry, yes, I didn't see everybody there, so.
Oh, I'm not fussing.
Oh, I know, but I just was scrambling for this button, so.
No. That's not necessary. I'm sure you were in and out looking for us. I had to step down to Judge Leonard's office for a minute, so I apologize. I was a little late.
That's okay.
Hmm?
Are we, yeah, I need the break, so.
That's why I took one. It looks like we can resume. Is that fair to say? Is the court reporter back? She is. I love that thumbs up. Mr. Durham, resuming the examination of Mr. Kilgore.
Okay. If we could put up, I think this is going to be D2, please. Okay. Mr. Kilgore.
Yes.
Do you recognize what's shown on the screen is the first page of D2?
Yes.
All right, could you scroll to the next page, please? And do you recognize that as well?
Yes.
And roll one more time. And do you recognize that as well?
Yes.
What is D2? And you can take the screen down now.
Those are that's work product of David Diamond.
Okay, and you can take the screen down now. Thank you very much. Okay, you say it's work product. Be a little more specific. I mean, how did do you know what it physically is?
Yes, he provided it to me. He provided it to me when I asked him, when I explained the court's order of what we had to turn over. And that was one of the documents he provided to me that he indicated was notes that he used in preparation to talk to Ross Harris.
Okay, and now the and did he also provide you the other three documents what were in D1 earlier?
Yes, sir.
Were they all
those 6 pages total? Those 6 pages total were the 6 pages that I turned over as a result of the court's order on the state's motion to compel. In my pleading where I turned those documents over, I did not attach a copy of those 6 pages because I did not want them to become public record. In fact, I made a note in the pleading that the record would be supplemented by a thumb drive at a later date. I made you aware of that, and you advised me that I did not need to supplement the record because those pages would be identified during the motion for new trial hearing.
And they have been done, but also let's take back to the trial of the case. Do you remember anything going on in the trial where there was a discussion about how the notes are going to be utilized by the state after you had provided them?
You mean discussion between the lawyers?
On the record, actually, in court. All right.
I just recall there was something on the record that the state suggested that they had done their own in-camera inspection. That somebody in the Brunswick DA's office had looked at the documents and decided that whatever was on the written pages wasn't anything they needed, so they were going to put them in an envelope or something.
Okay. So, but you do know that it was made part of the record, I guess, then that the state was using the typewritten notes. The state that's prosecuting, the prosecution team that is doing the trial.
Yes, we were very aware that the prosecutors in State versus Ross Harris had those confidential work product notes between us and the expert.
All right. And okay, so if you had not turned those notes over, would you have been inclined to call Dr. Diamond?
We would have called him.
Okay. Now, did you talk to Dr. Diamond at all about him not testifying?
Yes, we did.
Did you give him reasons why he didn't testify, why y'all were not going to call him?
Yes, we did.
What were those reasons?
We gave him all kinds of reasons. It's my recollection. So he was very hurt. I believe that he took it very personally, and he was very hurt. And we meaning me, I tried to explain to him that he was going to be subject to cross-examination with those notes in a manner which there was nothing I could do about it. And the state was going to be able to make those notes say whatever the state wanted them to say. They were going to be able to use those notes to put words in Ross Harris's mouth. And regardless, I'm sorry.
I was going to ask, but you mentioned you gave him several reasons. You gave him other reasons as well.
Yes.
Okay. All right. And you said he was hurt. His feeling, I mean, your testimony just then was he was hurt and kind of took it personally when y'all told him you weren't going to have him testify. Yes,
that's true.
Okay. All right. What other reasons did you give him?
I distinctly recall telling him that the court had ruled against us on matters of law that we believed were contrary to law, and that should he take the stand, the state could always object to him giving his opinion in regards to other similar cases he had worked on. And I'm what? Sorry.
Okay. And did you ever tell him that y'all thought, because did you ever tell him y'all thought things were going okay and that he wouldn't be needed?
I'm sure that we did. I'm going to be honest. We tried to let him down easy, and I think there were a number of things that we told him to try to be a salve to his very obviously hurt feelings. He'd been working on this case for over a year, and I mean, we probably told him lots of things.
Okay. All right. Well, now let's go back to your next prong. You told us earlier that you had two primary focuses on this trial. Do you recall that?
Yes.
And no, let me go back a little bit more about the notes and things. The PowerPoint. Let's talk about that for a bit. Now, when y'all had a PowerPoint that you gave the state early on.
Yes.
But that was before Dr. Diamond even had an opportunity to talk to Ross. Is that correct?
That's my we gave the state a PowerPoint early on. Whether or not that was before or after he talked to Ross, I just can't recall specifically.
All right. Now, I think you had mentioned earlier that the case was just evolving in such a manner that it was a slower evolving case. Did that have any play in the PowerPoint issue?
Well, of course, as we obtained more information and more evidence, and so sort of solidified what the defense was going to be, we would pass that information along to David Diamond, and it was up to him whether he was going to incorporate that into his PowerPoint or not. But let me also point out, please, that David Diamond was an expert in lots of cases of where there was memory failure and a child was left in a car. And over the course of the time that he was involved in our case, he was involved in lots of other cases. And he also spoke in academic settings and in legislatures. And I think that his PowerPoint evolved over the course of this case, but just simply because of the work that he was doing in this field.
Okay. Now, what did you disclose to the state about Dr. David Diamond?
They received his CV. We also filed I think it's a 2-paragraph statement on the subject matter that the expert would be giving testimony on. We gave them PowerPoints.
Okay, and well, I guess in the CV was his contact information so they could call him.
Yes, we provided his address and contact information, which of course the state already had because the state had tried to hire him before he came to work for us.
Okay. All right, and then when you turned this material over to the state, did Dr. Diamond do any scientific reports?
No.
Any testing?
No.
Okay. Did he, were y'all presenting any mental health defenses at competency or anything like that?
No.
Do you, is there anything that you felt under the law that you should have provided them that you did not?
I think if anything, the answer to the question is no. No.
Okay. And the PowerPoint, what was your position on having to give the state the PowerPoint and giving it to in the middle of the trial or near the end of the trial?
Well, the PowerPoint was a demonstrative aid. It was simply it was a series of slides which was going to aid the witness in his testimony. It was not going to be admitted as a piece of substantive evidence, like the digital recreation that the state did. I mean, this was simply some slides that were going to aid the testimony of the witness, and so it's certainly not uncommon for that type of demonstrative aid to be amended, updated as a case goes along, and as you get closer to trial. And when the witness gave us the demonstrative aid, we turned it over to the state. We gave it to them so that they would have an opportunity to go ahead and see what objections they were going to have.
And you did that before you put up Dr. Brewer, before you told Dr. Diamond that he was not going to testify?
Yes.
Now, Did y'all have ongoing conversations with the state about this PowerPoint? This is just discussions about Dr. Dinah's possible testimony? Do you have any recollection of that, I should say?
Well, I know that we did email back and forth with one of the prosecutors about the PowerPoint, and the state indicated that they had reviewed it and had objections to certain slides.
Okay.
So yeah, it was an ongoing open conversation. As a matter of fact, it was something that was discussed in open court.
Now, when did you back to the notes? When did you turn those over to the state? Do you recall exactly when?
I do not have a copy of my disclosure, but it was in volume 5 of the trial, which would have been sometime the second week of September, roughly, when we were in court on the state's motion to compel, and the court ordered that we turn them over the next day, which we did.
And the judge directed you to turn over, and did you have an opportunity to redact anything?
No, she said everything.
All right, and you turned it over when she told you to turn it over?
Yes.
At that court hearing. Okay. All right. And do you remember when the order itself was signed? But August 29th, ring a bell. You got it.
Well, so there was a prior, there was an order sometime in August, maybe, I believe. And then we filed a motion for that order to be reconsidered on September the 6th, 2016.
Okay. And the motion to the order on motion to compel, if it was, I told you it was August 29th, but it was filed. Would that sound about right?
That sounds right. Do you mind speaking up a little bit?
I'll try to scoot closer. Yeah, I'll try to. I don't think I've talked this much in a year, so. All right.
Sorry.
If we, now I'd like to go to the second prong of your defense that we have been talking about. You mentioned the state's theory of the case and motive earlier. Tell me about what the motive part of that. What was the state's motive in this case?
Well, the state's was suggesting that Ross wanted to live child-free to pursue extramarital sexual liaisons, and that he tortured and murdered his child so that he could live child-free.
Okay. And that was, we mentioned briefly earlier about some of the motions that you filed in the case. And was that part of trying to attack maybe the motive issue in the case?
We did. We were laser focused on challenging the credibility of the police officers and the experts in order to undermine what we believed was a contrived and trumped up motive.
Okay. Now there was a Reddit or something like that was discussed where Ross had replied to something. Do you know what I'm referring to? That kind of the state was using as part of the motive basis.
So there was a couple there. I mean, there was a lot of social media evidence in the case, but the one that was very, very problematic was an image that I want to say was on, it may have been on Whisper, that says, I hate being married with kids. Is that what you're talking about?
That was the one that I'm referring to, yes.
Okay. My recollection is that that was an image that was pulled off of Whisper, the Whisper app, social media app. And Ross did not type that. He did. Those were not his words. But of course, the state. My recollection is they blew that up and used it to suggest motive because he responded to that. He responded to that social media post, and his response was, "I love my son and all, but we all need escapes," or something of that nature. Of course, that Ross's response, of course, was benign and true. Any parent of a child needs to get away from time to time. But that was something that was a piece of evidence that we fought against a false suggestion that it was nefarious and indicative of intent to kill.
And you mentioned it being what you considered a false narrative. How were you going to attack that? What did y'all determine the best way to try to attack that?
Well, the police department gave us plenty of ammunition, and it started early on with the search warrants that the police, the affidavits that the Cobb County Police Department swore to the magistrate court of Cobb County, swore to magistrate judge over and over and over. The Cobb police detectives gave false testimony, lies. They lied to the magistrate judge. And, our belief was that was objective evidence because it was in writing. And in fact, in opening statement, we actually put up on the screen some specific language that was used in some of the search warrant applications. In opening statement, we put up on a screen one of the warrant application, or several of the warrant applications said during the interview with Justin, he stated that he recently researched through the internet child deaths inside vehicles and what temperature it needs to be for that to occur. There was also oral testimony given that he made statements regarding that he had researched how long it takes someone to die inside a vehicle and what temperature it needs to be. There was a whole bunch of stuff in the search warrant affidavits that law enforcement swore to, that detectives swore to under oath in this case. And we felt that was the biggest, best, and strongest evidence to demonstrate that the police in this case were willing to lie under oath to a judge to turn the narrative in their favor. To concoct this motive. In addition to the search warrant affidavits, there was also a lot of false testimony that was given in the probable cause hearing. That was given by Detective Stoddard, and we were able to cross-examine Detective Stoddard about his prior testimony. So that we brought out an opening, and we got to challenge the credibility of law enforcement regarding the false testimony during the probable cause hearing. But the search warrants, the affidavits, the false testimony under oath, we were not allowed to go into.
Okay. So when you're talking about the search warrant issue now, how are you planning on trying to attack that? Procedurally, I guess.
Well, we wanted to question the detectives about it.
Well, we'll start. Which detective did you want to testify?
Well, we attempted to cross-examine the case agent about it. The lead detective, who was Detective Stoddard, he was the one who had conducted the interview with Ross, and obviously had full knowledge that that the magistrate court was lied to.
Okay, and was there any other people you want to talk to about those specific search warrant issues?
Well, the state objected to any examination of Detective Stoddard about the false testimony under oath for those warrants. And we had a bench conference, and the prosecutor, the prosecutor told the judge, if you get the right detective, basically, if you get Detective Murphy, then it won't be hearsay. And so we said, okay. So we made arrangements to get Detective Murphy down. I told the judge, I said, well, we'll call him. We'll call him as a witness. And so arrangements were made to get Detective Murphy down to to Brunswick. He got down there and took the stand. And in between the bench conference and the officer actually taking the stand, the state had decided that, well, maybe it was hearsay. And so they completely changed what they were telling the court. And we were not allowed to question Detective Murphy about testimony he gave under oath in this case to a magistrate judge over and over and over. False testimony.
All right, as far as Detective Murphy, that was going to be T. Brian Lumpkin was going to do that testimony, correct? That questioning.
So we had based on the things that we were individually working on toward the end of trial, it was decided that Brian Lumpkin was going to handle Detective Murphy. And I can't remember specifically why we made that decision. I think some of it had to do with the fact that, first of all, Brian is very, very good, and he had essentially destroyed a state's witness earlier in the case. That was Grimstead, who was a.
I want you to answer just as far as the question was Brian Lumpkin going to question Murphy? I'm going to
Yes.
go into the other witnesses in a second. Now, you mentioned Dunstan and Grimstead. Now, a while ago, you also mentioned the recreation or 3D animation, and that y'all had objected to at trial, and it was allowed in over objection. Did you was that part of the plan to attack the state's case, was to go after the recreation as well?
Very much so.
Okay, and that was going to be done. That questioning was done partly by T. Brian Lumpkin, but also by Carlos Rodriguez.
My recollection is that Carlos Rodriguez cross-examined David Dustin, who was the Pharaoh. He was the witness that they used to get that piece of evidence in. Okay,
and so then we go to, but they're part of the trial team and they're part of the strategy, although working together on this defense theory about how to try to attack the state's case and the credibility of their evidence and their testimony. Is that fair?
Absolutely.
Now, there was another state's expert that testified named Jim Persinger. Do you recall his testimony?
Yes, I do.
And was the same theory going to be used in trying to confront Persinger's testimony?
Absolutely. We were going to challenge his credibility and attack his credibility. And I will tell you, during his direct examination, we just got a gift that fell in our lap, which was the witness put on this charade in front of the jury where he clearly didn't know what he was talking about. And it just basically was a gift. It just fell in our lap. And we had an opportunity to essentially destroy the credibility of the state. I mean, this was their primary main expert for the state of Georgia. And we had a chance to destroy his credibility in front of the jury, completely destroy him. And the state objected.
Let me just cut you off, but was this done by a different attorney? Was this Carlos Rodriguez's witness?
Yes.
Okay. And so, but that was also part of your strategy in attacking the state's case, was to go after this witness and his credibility and what he had done or not done.
Yes, of course.
All right.
And I was the one that was giving closing arguments. So all of the challenges that to credibility during the trial of the case were going to be things that I either could or could not use in closing argument.
And y'all were talking about that, what you needed to do and what you were trying to do.
Absolutely.
And you gave the opening statement as well, did you not?
Yes.
And a lot of the things we've talked about up to this point, you presented an opening statement because you were, let me rephrase that. Why did you present an open statement?
Why did I give an opening statement?
Oh, no. Why did you present these issues in opening statement? The issues you talked about as far as when you're going to attack the police credibility on the affidavits and the false testimony at the PC hearing and all these other things. Did you think it was important to your case?
It was extraordinarily important. I will say again, there was an allegation of a baby that died in a horrible way, and it was alleged that the father did it intentionally, and there was a mountain of bad character evidence. So we were very much starting in a hole. We could put up all of the accident memory failure evidence in the world, but unless we demonstrated conclusively that the state's witnesses were liars and were not credible, and had concocted and contrived this motive, unless we could do that, we knew we were going to be in trouble. And so it was a concerted effort with every witness, not just the offense witnesses, but to attack the state's witnesses specifically, to show they were not credible.
And when you talked about this this evidence in the opening statement, did you tell the jury you're going to see this in evidence, you're going to see this, and you promised them that these things were going to come out?
Well, I definitely promised them that they were going to see where the Cobb police detective lied to a magistrate judge under oath to obtain search warrants, and obviously I did not fulfill that promise because we were not allowed to question the witness about his false testimony under oath.
And did you have any question in your mind legally that you would not be able or would be able to get into that testimony?
Zero. It's zero.
Zero what?
There was no question at all, ever in our minds, that we would not be allowed to question a law enforcement officer who had given false testimony under oath in this very case about evidence which was in the case.
Okay. Now, you mentioned one, let's go back to the specifics here. You mentioned one witness that you were cross-examining, and that would be Detective Stoddard. Is that right?
Right.
All right. Talk to us again about how you tried to approach it with Detective Stoddard.
How I tried to approach him?
Approach the issue regarding the search warrants. with Detective Stoddard?
So Stoddard testified over a couple of days, and we used him to get a lot of different information out, but we definitely challenged his veracity and his credibility when we pointed out specific false testimony he gave under oath at the probable cause hearing. And then was sort of a transitioned into was going to asking him if he was aware about additional false testimony that was given under oath in the case. And of course, I was going to go into the false testimony for the search warrants. And that's when the state objected and we had a bench conference.
Okay, and when you did that, I mean, what was it? You mentioned the purpose, but I want to be clear, was the purpose to relitigate the search warrant issue? Was it to attack the credibility, or was it both? What was it? What was the purpose?
It was solely to challenge the credibility of the police department and show that they were willing to lie under oath in this case so the evidence would fit their narrative and fit their contrived, trumped up motive. We absolutely did not intend to relitigate the search warrant. There was no reason to. All of the evidence was already in the case. Everything that was challenged earlier regarding the search warrant, it had already been admitted. It was already in the trial. There wasn't any reason for us to try to relitigate the search warrant itself. We were going after the credibility of the state by going after the credibility of their law enforcement officer who was willing to lie to a judge.
Okay. And so you weren't able to do that. And I think, again, you mentioned that you had the bench conference and called Detective Murphy as a result of that.
Yes.
Okay. Give me 1 second, Judge, please.
Yeah.
Anything else? Hang 1 second. All right, let me ask you just a couple more things. Mr. Kilgore, you mentioned early on about the child-free lifestyle, but what was that? What were you referring to there?
Well, that was both regarding a specific piece of evidence and the bigger picture of the state's theory of the case and the state's motive. The bigger picture was the state was suggesting that Ross wanted to live child-free so that he could, pursue extramarital relations. But there was specific evidence regarding a direct message chat between Ross and some of his friends, particularly his friend Alex, where Alex forwarded him some link, I believe it was a Reddit link, to a kind of a subreddit group called Child Free, which purports to be a group of individuals who want to live a life without children. And early on in the case, the state knew about this evidence very, very early because they brought it out very disingenuously and falsely in the probable cause hearing and made the suggestion that this was something that Ross had subscribed to, when in fact, when we finally found the evidence and looked at it, it was all a lie. In fact, Ross had responded to his colleague's direct message with the word grossness, which to us was pretty clear that it was not something that Ross subscribed to. But that's the only place in the evidence that child free. I mean, that's where it was.
And now, I got 2 or 3 more questions, but I want to go back as far as the purpose of you asking the questions regarding the search warrant and questioning the witnesses in that regard and the state's witnesses. I mean, was that to show any bias, any motive? Are you doing the search warrants? I try to relitigate those. I don't know if I've asked that, but I want to make sure I got that clear. Was it for the bias and motive? Was it for search warrants? Was it for any other reason?
So Mr. Durham, I apologize. You went out. Do you mind restating that question, sir?
Sure. I just want to make sure we've been talking a lot. I want to make sure I have this correct. But now, when you're trying to cross-examine Detective Stoddard and also with Detective Murphy, and you're going after the search warrant issues. Now, was the purpose of that for the bias and motive? Was it for trying to check their credibility in that regard? Was it to show prior inconsistent statements, or both?
All of the above. All of the above. And frankly, we're using the phrase search warrant because that was the context in which the false testimony was given. The context doesn't matter. What mattered to us was this was sworn testimony under oath about this case by a detective in this case. And I went over with Detective Stoddard at great length all of the different, for pages, all of the different responsibilities that Detective Murphy had. Detective Murphy was no bystander in this case. He was intimately involved in the investigation of this case from day one. Intimately involved. And
okay. And so lastly, you filed a motion for new trial in this case.
yes.
Okay. One of the issues, I just want to make sure we're clear here on the record. You had talked about the bias, I'm sorry, the bad character evidence and of that nature. Now, you listed three examples in the motion for new trial filed on behalf of Ross Harris. Do you recall that?
Yes.
Now, there is no. Was your intent just to do it for those 3 people, or was that for everybody? You just use those as an example, or how did that come about?
Those were just examples. We objected pre-trial to all of the mountain and cavalcade of bad character evidence, which didn't have anything to do with the underlying charges.
Without going into a lot of detail, just the question would be, the witnesses came in and they talked about graphic language and text and photos and things like this. Is that is what the character witnesses you're talking about?
Yes.
Well, did that information also get relayed to other witnesses at trial, back in front of the jury again? For example, if you brought up a witness, were they also informed about those bad acts in front of the jury again?
Of course. I mean, it seemed to us like every witness that took the stand, the state wanted to relitigate the bad character by showing pictures of Ross's privates or calling attention to the fact that Ross had, done these morally inappropriate behavior.
I think that's all this time, Judge. Thank you, Mr. Kilgore.
Cross-examine.
Thank you, Judge. All right, Mr. Kilgore. You've done a number of murder trials, is that correct?
I have tried murder cases.
As both a prosecutor and as a defense attorney?
Yes, ma'am.
This particular case, did you feel you had enough time to prepare this case to go to trial?
Yes, ma'am.
And you met repeatedly with Mr. Harris, is that correct?
Yes, ma'am.
And it's obvious that you really focused in on a two-pronged defense strategy, is that correct?
That's fair.
All right, and the first prong was accident, which is an affirmative defense that has to be disproven by the state beyond a reasonable doubt. Is that correct?
Yes, ma'am.
Okay, and part of your strategy there in trying to prove it's accident is to explain how it was accident by putting up an expert such as Dr. Jean Brewer to explain prospective memory and how someone could potentially have an error in memory and therefore forget their kid in the car.
Yes, ma'am.
All right. And the second strategy was to attack law enforcement and their credibility. Is that correct?
Yes.
And the reason to attack the credibility of law enforcement and the detectives in this case was to undermine this idea that there was, in fact, a motive and a reason for Mr. Harris to have murdered his child.
Yes.
And have you used attacking law enforcement's credibility as a strategy in the past?
Never anything like this. I have never, in my almost 30 years of practice, I have never been involved in any case which there was so clearly incredible evidence, where there was so much evidence against the credibility and veracity of law enforcement. Anything like this ever in my career.
What I asked was, have you ever used this as a strategy in a case before?
As we speak right now, I cannot specifically recall that challenging the credibility of the veracity of a law enforcement officer was such a primary part of the defense. But in a general sense, it is certainly something that is common that we do is to challenge the credibility of police officers.
And you do that through cross-examination, showing that they may have made an error in the statement in their report, that they didn't do something that they should have done, things along those lines?
Or that they lied under oath.
And it was not in dispute that your client had left Cooper Harris in his car.
Of course not.
And it was not in dispute that Cooper Harris died because he was left in the car.
Of course not.
And so therefore the main issue at trial was the first prong of your defense. Was it an accident or was it intentional?
That was the legal component. That was the legal basis of the defense, was that it was an accident because of a memory failure.
Right. And the police interviewed Mr. Harris, is that correct?
Yes.
Was that shown to the jury?
Yes.
And at that time, he said it was an accident.
Yes.
And would you agree that a number of the things that your client told the police during that interview were things he also reiterated to Dr. Diamond, and Dr. Diamond wrote those things in his notes?
I would.
Did he freeze?
No, I think Mr. Kilgore is looking at his notes.
Okay.
So my response would be, there were things that Ross Harris told the detective in the interview that the lawyers conveyed to Dr. Diamond.
Okay. But I thought you said that Dr. Diamond actually was given Mr. Harris's interview to watch as well.
He was.
Okay. And I guess what I was asking is, did Dr. Diamond then follow up with Mr. Harris about topics that Mr. Harris had already talked to the police about?
Presumably he would have. But I guess what I'm getting at is, in these notes that were turned over, what is being conveyed to Dr. Diamond is clearly being conveyed by the lawyers. I mean, these are notes from our conversation with him, which he used as a go-by to then go and talk to Ross.
I understand. All right. And this is just for the record. I know these are a series of silly questions. Just go with me. You'd agree that my name is Linda Dunikoski and that I'm not Chuck Boring, Susan Treadaway, or Jesse Evans, correct?
Yes, ma'am.
All right. And I didn't try this case, did I?
No, ma'am.
I'm just the appellate attorney, correct?
Yes, ma'am.
And today is December 14th of 2020, correct?
Yes, ma'am.
And we're not in Brunswick, Georgia, are we?
No, ma'am.
All right. And you filed a lot of motions in this case. I think we got up to motion number 28. Is that correct?
Well, we didn't file as many as you'd have in a death penalty case, but we certainly filed over 20.
And there were 7 different days of motions for motions hearings, right?
There were multiple days of motions hearings.
And your team put up numerous witnesses on Mr. Harris's behalf. Is that correct, during trial?
Yes, ma'am.
And one of those witnesses was Dr. Jean Brewer, correct?
Yes, ma'am.
Right. And part of your trial strategy, I believe, during opening and closing, was that you urged the jury to completely disregard the state's motive evidence. Is that right?
I'm certain that we did.
Well, that was one of your main strategies, right? That you can't believe this motive evidence, right?
Yes.
And your team did everything to conduct thorough and sifting cross-examinations of the state's witnesses, correct?
We did everything that we were permitted to do.
Okay. And sometimes a lot of attorneys go into court attempting to put certain evidence before the jury, and sometimes the court will rule against them. That happens, right?
Sometimes the court is correct, sometimes the court is not correct.
All right, so let's go ahead and talk about timing issues. Well, I'm going to go ahead and transition now into the ineffective assistance of counsel claim 1, which is the failure to call Dr. Diamond to testify. So first off, I believe you testified earlier that the whole point of calling Dr. Diamond was to have him opine that this case was in fact a case of memory failure, and that he was going to be able to compare other cases to this case where children were forgotten in a car, and that he was absolutely going to have to disprove that this was intentional. Is that correct?
So you've asked us a couple of questions there. I'm gonna ask you to break that down for me, please.
Sure. The whole point of calling Dr. Diamond was to put him on the stand to opine 2 things. It wasn't intentional. It was a failure of memory systems, right?
Those were 2 of the reasons, 2 of the significant matters that we certainly wanted to get from Dr. Diamond, but it was in no way the entirety of what we expected or wanted to get from him.
And you worked with Dr. Diamond on the strategy of your case, correct?
Yes, ma'am.
And you provided him with the evidence from the state.
Yes, ma'am.
Okay, so the evidence in this case came from the state, and it was given to you, the defense attorneys, who then handed it over to Dr. Diamond, correct?
Of course.
All right. And the state's strategy in this case, or rather the evidence, was not a big giant secret, was it? It was obvious that the state had indicted your client and was claiming that he intentionally put his child in this car. Very generally, that is true. That is what the state suggested happened. All right. But what I'm getting at is the state didn't try and play hide the ball with what it was doing. The state put it out there. We've indicted him. He murdered his child. These are the charges, and here's the evidence, and handed it over to you, right?
Well, that's no different than any other case.
All right. And you talked with Dr. Diamond about your opinions about the evidence. Is that correct?
At length.
And about your strategy in the case.
At length.
So Dr. Diamond was not an impartial expert.
Well, he was in a position to give an opinion, or opinions plural, which supported the defense theory. So in that regard, he was favorable for the defense, or he would have been favorable for the defense, and what he had to say would have been contrary to the state's theory.
So do you recall, well, have you had an opportunity to review your opening statement?
Yes.
All right. And do you recall that in your opening statement, you didn't actually name any expert by name? You just said you're going to hear, and then you kind of laid out what prospective memory was and what memory failure was.
That's true.
All right. And have you spoken to Dr. Diamond since 2016?
I think we may have exchanged an email about 3 years ago. I think at some point over the last 4 years, we may have touched base. I mean, obviously, we became fairly close working together over a year and a half.
Right. And so I believe you testified, I just want to make sure I got this right, that you believe Dr. Diamond was going to be able to take the stand and say that his opinion was this case is a result of a failure of memory systems.
So I want to make real clear what my testimony is in this regard. If David Diamond had been asked the specific question that ADA Chuck Boring had asked Gene Brewer, first question asked, it would have been a very different answer if he were asked that same question. What he would have testified to was, yes, in this case, it is my opinion that what happened was a result of a memory failure. Now, Mr. Dunikowski, that said, I doubt very seriously that Mr. Boring would have asked that specific question to Dr. Diamond, because that probably goes to the ultimate issue. So if Dr. Diamond would have testified, we would have phrased the questions to him more along the line of, so what you observed and evaluated in this case, was it consistent with what you know about memory failure? Was this case consistent with your study of memory failure? But we would have taken it further and said, was what you learned in this case, what you observed in this case, was it consistent with other cases you've worked on and studied and been involved in where it was determined to be a memory failure where a child was left in a car? Because you see, Dr. Diamond had, again, he did forensic work. He was actually hands-on working on these cases. And so I certainly believe he would have had every right to give that opinion that what he saw in this case was certainly consistent with other cases he'd worked on involving memory failure, and been able to give specifics about what facts or characteristics were similar.
Wouldn't the state, in your opinion, wouldn't the state have objected to that testimony, given he's basically saying, well, Susie shoplifted in this manner, so therefore Janet had to have shoplifted. It wasn't accidental that she put it in her purse because Susie did it this way? And wouldn't the state have objected to that sort of testimony?
So we're talking about the testimony of an expert who is giving his opinion based on all of his work, all of his study, and his study is studying these very cases. So I think that it's certainly within the realm of the expert to give that very testimony. But to answer your question, Ms. Dunikowski, I think the state was going to object to everything, as they did throughout the entire trial. Anything they didn't want the jury to hear, they were going to come up with some sort of objection, hearsay, foundation, whatever. So yeah, they were probably going to object.
Okay. And I believe you previously testified that one of the reasons when you were talking to Dr. Diamond and telling him one of the reasons we didn't put you on the stand was that the state's basically probably going to object that this opinion where he compares other cases where other people did things to this case, that would be objected to, and there'd be a ruling, and the ruling might not go favorably.
I don't remember the exact words, but that was certainly the kind of stuff that we were talking to him about.
All right, so when we get back to the ultimate issue. So you clearly understood the court's ruling when the court ruled, I believe on August 29th of 2016, right prior to trial, that no expert could go into the ultimate issue under Rule 704. Is that correct?
Sure.
Okay.
Well, under Rule 704, I don't have the order in front of me.
Allow me to share my screen with you.
Okay. And I don't have the statute in front of me either. This was not a mental health expert. I mean, yeah, I understand that very clearly.
Okay, so, and just for the record, if you don't mind, could you just basically start right here with fines?
Okay.
I'm sorry, I was unclear. Could you read it out loud for the record?
Finds that testimony by defense expert Dr. David Diamond as to the ultimate issue regarding the defendant's intent to commit the crime or lack thereof, defendant's mental state or mental condition constituting an element of the offense or defense thereto, or defendant's mens rea would be inadmissible and inappropriate.
And what section and statute does the court cite then?
24-7-704.
Okay. And you just read from which order?
Whatever you showed me. Order on state's motion in limine to exclude expert opinion on the ultimate issue.
And what date was that issued?
August 29, 2016.
Okay. So you were well aware of this before you started trial on September 12th, 2016, that Dr. Diamond was not going to be able to opine in any way, shape, or form that Ross Harris's actions were either intentional or a result of memory system.
And because of that, it was certainly our intention to pose questions in the form of whether or not what he observed was consistent with his study of memory failure.
All right. Now, with regard to the state's motion to compel, the state, well, first off, the defense filed the defense discovery on the state on April 6th. I apologize, April 4th, 2016. Is that correct?
I don't have any idea. If you say so, I mean, the record should show whatever date we filed things.
And do you recall filing with that, I'm looking for my, there we go, filing with that certificate of discovery, the CV of Dr. David Diamond?
We definitely provided that to, the state.
All right, and you mentioned, I think, the 2-paragraph summary at that time.
Yes.
All right, so I'm gonna have you take a look for me at State's Exhibit S1. And we have a 47-page document. Does this look familiar as the CV of Dr. David Diamond that you provided the state with on April 4th, 2016?
As far as I know.
At this time, the state would tender in State's Exhibit number 1.
Any objection?
Mitch, there.
Sorry, Your Honor, I could, with the shared screen, I could not locate the mute. It was covered up.
I know.
But we have no objection.
It's admitted.
Right. And then, Mr. Kilgore, I'm going to have you take a look at then State's Exhibit number 2. And does this look familiar to you as the disclosure to State's Counsel of summary of expert testimony that you served on the state on April 4th, 2016?
So bring it all the way down so I can see the whole document, please.
Sure thing.
Keep going, please.
No problem. Just let me know.
Keep all the way to the bottom. Yes, it looks like something we provided.
Okay. And when we see page 1, Dr. David Diamond with the CV attached, is this the 2-paragraph summary that you provided to the state as to what he was going to testify to?
Yes.
At this time, the state would tender into evidence State's Exhibit S2.
No objection.
Admitted.
Right. And so obviously before the court's ruling on August 29th of 2016, you have here that Dr. Diamond is anticipated to provide expert opinion that defendant's failure to take Cooper Harris to daycare was not intentional, but a failure of memory systems. Is that correct?
That's what's typed.
Well, yes, I know that's what's typed, but is that what your intention was back when you served this on the state?
My intention was to get an opinion from the doctor as strong as possible that made clear that what happened in this case was a failure of memory systems or consistent with all of his study of failure of memory systems.
All right. And when the state served this on April 4th, do you recall the state then filing a motion to compel on April 11th, 2016, along with the motion to exclude expert testimony on the ultimate issue under 704, the motion to exclude defendant's self-serving hearsay, those 3 motions on April 11th, 2016?
So I don't remember specific dates, but I know that those motions were filed.
I may have a moment. I'm going to have you take a look at what I'm sharing right now. Does this help refresh your recollection as to the date the state's motion to compel discovery was filed?
April 11, 2016.
All right. And do you recall that what the state asserted at this point in time in its motion to compel was that on April 6th of 2016, that the state received its discovery, and that in the 2-paragraph summary, defendant notes that Diamond actually interviewed the defendant at some unspecified date and time, and that the state then spoke with Dr. Diamond via telephone on April 6th, 2016, and that during that conversation, Dr. Diamond disclosed that he created written documentation regarding the statement defendant gave him during his work on this case, and that the state specifically only wanted what Ross Harris had told Dr. Diamond in this case as he was basing his opinion on what the defendant had told him.
So I wasn't privy to the conversation between Dr. Diamond and the state, but I can tell you that is that the pleading there does not demonstrate what the court ordered that we turn over.
Fair enough. At this point in time, when you received this motion to compel on April 11th of 2016, did you ask Dr. Diamond to look at his notes so that you could review them to see what it was the state wanted?
I don't recall the specific language of the conversation, but I definitely spoke to him and let him know that we had been directed to turn over his notes regarding, or I don't remember how I phrased it, but I made clear that we were going to have to turn over anything related to his conversations or interviews with Ross.
And you let him know this after you got this motion to compel?
Yes.
And the first day of trial for the first go around in Marietta, that started on April 11th, 2016, and jury selection began the next day on April 12th. Is that right?
That sounds right. I don't have specific recall of the dates.
But it will be in the record.
Sure.
All right. And what happened with the case as it proceeded here in Marietta?
Mistried.
What was decided then?
That the case was going to be moved to another jurisdiction.
Do you remember the date it was mistried?
I do not.
How many days were you into the case before the mistrial happened?
Seems like it was a couple of weeks, maybe 3 weeks or so.
So we get to the second interview. The first interview Dr. David Diamond did with your client, Mr. Harris, was back in 2015. Is that correct?
The first interview or the second interview?
First interview Dr. Diamond did with Ross Harris.
I apologize. I just simply do not have I just don't have a sufficient reference to tell you with any certainty when when Dr. Diamond spoke with Ross. I only know that he did, but it was certainly prior to trial, and it seems to me that it would have had to have been no earlier than 2015.
And so the next time he spoke with your client would have been April 30th of 2016. Is that correct?
Dr. Diamond would be a better historian for that than me. I just don't, I can't tell you the date.
All right, well, I'm going to ask you to direct your attention here to the typed up notes and materials. You recognize these 3 pages as Defense Exhibit 1?
Of course.
What's the date at the top of that?
4/30/2016.
So at this point in time, the trial has already begun on April 11th in Marietta. There's been a mistrial, and at this point in time, you know it's going to be continued and moved to a different location. Is that right?
I'm not crystal clear on the dates, but if that's, I don't have any reason to doubt you regarding the dates.
Okay. So when Dr. Diamond goes to do this particular interview on April 30th of 2016, you'd already been prepared to go to trial once already, right?
We were constantly preparing for trial. There was never a stoppage of preparing for trial.
All right, but by the time he does this second interview on April 30th, 2016, you'd already served the CV, the 2 paragraphs, and a 22-slide PowerPoint presentation to go along with Dr. Diamond's testimony for trial.
That sounds right.
So looking at Defense Exhibit number 1, this section up here where it says first level criteria for my involvement in this case, this is actually Dr. Diamond talking about what criteria he uses about whether he's going to get involved in a case or not, right?
That's my belief that that's what that is.
So you were worried the state was going to cross-examine him on the fact that he used.
That's a big speculation on this witness's part. Now, he said that's his belief, but he doesn't know what's in Dr. Diamond's head, but Dr. Diamond has already testified to that.
Well, nothing on cross, just has more latitude than that, and I'll allow whatever objection.
Thank you, Judge. Mr. Kilgore, what I'm getting to is you've testified repeatedly about why this document worried you so much. This got in the hands of the state, and the state was going to use it terribly to cross-examine Dr. Diamond. So I kind of want to go through that with you to explore exactly what about this document caused you so much concern. So the first part, this first level criteria, that's about Dr. Diamond. The state would have basically, I mean, in your opinion, this is one of the reasons you didn't put this Dr. Diamond on the stand. So
no, ma'am, you're putting words in my mouth.
okay.
And it sounds like you're mocking my direct testimony. So let me make the record real clear. I don't recall testifying that I had a problem with anything about that interview one, that 1 through 4. I don't believe that I testified about that on direct. And I don't believe that I had any concern about that. But I will assure you, ma'am, we were extraordinarily worried about the rest of that document getting to the state and them having it to not only cross-examine Diamond, but suggest and put words in Ross's mouth. We were very concerned about it.
How would the state go about putting words in Ross Harris's mouth?
Sure. Well, I can't tell you what they would have done.
That would be speculation, correct?
I could tell you what they could have done. And any line that is on there, they could have suggested that these were things that Ross had said. And of course, they could have suggested that these were things that the expert was worried about, that the expert was concerned about after talking to counsel. Because it's on paper, the state could use its imagination to make those words mean anything they wanted to in order to fit their narrative, to fit their theory. And in fact, that's what the state did throughout this case.
So, yes. I'm going to pause and give some background noise.
Somebody needs to mute something. That is going on all afternoon.
So, Mr. Kilgore, if Dr. Diamond you're an experienced trial attorney, correct?
I have tried jury trials before, yes, ma'am.
So when a witness is on the stand and the opposing side mischaracterizes some testimony or something, what do you normally do?
Obviously object.
Right. And at that point, can the witness himself or herself actually clarify their answer and explain what's really going on and what the truth is and how the lawyer questioning them is completely wrong?
So the answer to that question is obviously yes, but I believe that is far too simplistic concept of what being in trial is really like. Because what can happen is the state can take that piece of paper, they could take the words that are on paper and they could stand and close an argument and say, well, David Diamond says those aren't his words, or he says that's not what he meant. Who you gonna believe? You gonna believe the guy who was paid by the defense, or your lying eyes right here on this paper?
So your concern with this being in the hands of the state is that Chuck Boring was going to be such a good advocate that he was going to go ahead and twist all of this up in a knot for Dr. Diamond and Ross Harris and then make these sorts of closing arguments. So your fear was actually of the state's attorneys being so good?
You betcha. You betcha. Look at the very first line in the state's closing argument. I love my son and all, but we all need escapes. Okay, that was something that Ross had typed out in a chat with somebody. Totally benign, absolutely benign. But yet the state made those words appear what they wanted them to appear to be. The state put its meaning to those words. And a mediocre lawyer can do that. And the lawyers in this case were better than mediocre. They were very good. So yes, I was extraordinary. All the lawyers were extraordinarily worried that when you put something in writing that was conversations between the lawyers and the expert, that the prosecutors were going to be able to throw that back at us and use it to make those words mean whatever they wanted them to mean to fit the state's narrative.
So
Listen, we would have called Dr. Diamond to testify in this case if we hadn't had to turn those notes over. That's the bottom line. He would have testified if I hadn't been required to turn those notes over.
I'm
So-
not sure what's exactly going on right now. Y'all are talking over one another. I'm not sure why. Let's quit for the day. I've got to call that criminal calendar from this afternoon and get it wrapped up. Y'all been working hard all afternoon since 1. We'll resume until 9 in the morning. So this matter is in recess.
thank you, Judge.
Yes.
Thank you, Judge. I've learned how to find the mute button.
That can be convenient.
Well, I think my wife wants me to have one of these herself. So.
I wasn't going to say it, but I did think it. All right, y'all have a good afternoon. I've got other things to address. I'll see you all in the morning. All right, what do we have going on? What's left?
One status on the motion calendar is position 1.
Mr.